Hey.
Hi, Greg.
All right, I guess we're live.
Yeah.
Hey, everybody. Chuck gave us some last minute news that he couldn't be on, so his assistant set this up. Thank you very much. And I guess Aaron and I are driving on this. So, Aaron, we just had some interesting. We had an interesting morning. That we were in court this morning. Well, not really in court. We were like on a conference call with the government, kind of in anticipation of going to court. But why don't you kind of like explain for the I-601A case?
Sure.
Do you have any people that are on? What happened this morning and where we are on the schedule?
Sure. So we had set a call with government counsel, like Greg was saying, to discuss what's going on in the 601A case. And a lot of it was kind of logistical type of conversation, but parts of it were what the government planned to do in response to our complaints and what the next steps are. So let me kind of set kind of where we are and then what's going to happen next. First, the motion for class certification is pending, and we got the response to our motion yesterday or the day before. It all blends together. But we have our reply due on the 9th. So we are working on that. And at least in theory, there could be a hearing on it on the 10th. However, I think that there's some expectation that that might not go forward that quickly. Then separately, we have requests for discovery. And by discovery, I mean we want to know what in the heck happened behind the scenes. Why did processing times go from 4 months to 39 months? What decisions were made? What resources were allocated or not allocated to processing these applications? And the government wants to delay that. They want to say, let's not do any of that discovery until the court makes decisions on a motion to dismiss that they're planning to file, but they have not filed yet. We said, no, we don't agree to that. There's no reason to delay discovery. The whole case is about unreasonable delays, and we're not going to further delay this case on behalf of our plaintiffs just because you want to, because you're planning on filing a motion in the future. So we discussed that and made our position clear that we're not agreeing to any of those delays. In fact, we filed a written reply on that issue yesterday, saying that we're against delaying the discovery schedule. And I think it was really solid. I really don't think that they have basis or good cause to delay discovery. And so my hope and expectation is that the court will agree with us and that the schedule will continue. So then what happens next? We're expecting the government to file a motion to dismiss. They do that in many, if not most cases, and they'll have their bases for the motion to dismiss. They told us on the phone what they were. We don't think that they're valid, and we feel good about our ability to respond. So that'll be upcoming. And we also broached whether there might be potential for settlement opportunities. We won't get into the details of discussions there, but they're very preliminary. So I don't expect anything to come of that anytime soon. Greg, anything I'm missing on that?
I mean, they kind of like previewed a little bit of what their strategy is going to be. Aaron was mentioning that. Another thing is they will probably try and fight whether this case can be heard in Seattle, in the Western District, and whether they can, try and force this case to be split up and moved all over the country. That's not a secret that they would like to do that. They kind of got, they're back to that fluky decision that happened a couple of years ago in Maryland when we had an 80-something-year-old judge who was trying to get rid of a case that did that. I don't see that, as really being something that is a pretty, is a significant threat. But obviously we'll be prepared for that. I guess that Aaron, the question is, it's sort of why I think that, according to our calculations, there's no work that's happening on any of these cases. So that's why I think the discovery is going to be really interesting, because I think that there had to have been an affirmative decision to just cease work on it and directing all the people that were working on these cases into other product lines on there. And we're presumably going to find that if we get discovery. There's just the dates keep getting longer and longer, which is an indication that they are getting applications and not working on them, and just basing the estimated processing times on the larger volume of cases that are now sitting in the queue each month.
Yeah.
So it's not last in, first out, or anything. It's basically all in, no out.
Exactly. All in, no out. I feel like that's a bad processing system.
All right. So let's talk about some of the other cases that we have going on. I don't know are there developments in the Jane case at this point?
There are, but I think we'll wait for Chuck to be on next time to give any developments on that. I know he emailed the plaintiffs for that, I think yesterday or the day before, so they got the updates there. But there will likely be further updates, I think, on the call next week.
All right. What about Ukraine at this point?
We can share that the case in the Court of Federal Claims has been dismissed. That is going to be refiled. I think that's about all we can say about that right now. Is there anything else that you wanted to share about that publicly?
Well, I mean, we are telling everybody we're looking for a DC resident as a plaintiff. That is proving to be more challenging than I thought, where we've got tons of volunteers from the Maryland and the Virginia suburbs. And it doesn't seem like anybody from Ukraine wants to actually live in the city. But if there are any of those folks that are on the call, if we find that person or persons, it will accelerate things. And that's all I think we should probably say at this point. But if you know anybody who is Ukrainian parolee in DC who filed an I-765, it would be nice to find that person. That's all I think we should say, probably.
Yeah, I agree.
All right. Well, we have two new cases that are in onboarding, and we're early on that. So one is a case suing for delays on I-601s, which the situation for those waiver applications is pretty similar to the I-601A case as far as the length of the delays. And we've just started onboarding on that one. And the other is one that I'm pretty excited about that we're going to litigate on, and that's prevailing wage delays in labor certification cases. The delays in those cases have gotten longer and longer, and they have a lot of repercussions for people just beyond the ultimate delay in getting a green card, because you can't file the actual perm application until you get that done. But for people that are, for example, needing AC-21 extensions and other benefits, they can't get to that until they actually get an application filed. Department of Labor hasn't really, they've been using the excuse for a couple of years that I guess back to the Purdue case that we sued on, I guess in 2019 or 2020. I forget whether it was 2019 or 2020, was the excuse at the time. That's why they were taking longer on prevailing wage determinations. But I think that was their excuse at the time. But I don't know what their excuse, if there's anything they could still be claiming pre-COVID or COVID as far as what the delays are all about. But that's something that we're going to litigate on. So hopefully if you're in that situation and you're interested in participating, go to IMMPAct Litigation. Just spell it the correct way, the way it's on the logo on the screen, IMMPACtlitigation.com, and you can find out information on that suit. Aaron, do you want to add anything about either one of those cases?
The 601 case, some of the people on the who are watching might be 601A plaintiffs, and I'll explain kind of again what the difference is. For the 601 case, this is specifically for people who for applicants who are already abroad. So people who are doing consular processing, They're already abroad. They didn't qualify for the I-601A waiver for whatever reason, and they're doing an I-601 waiver. And they're kind of in a similar situation, like Greg was saying, that it's the processing times have ballooned and are crazy. But the difference is that they are already separated from their families. Their families generally live here. They're waiting to get back, and the agency's just not processing the applications. So the way that we're going to do this case is a little bit different than how we've done some cases in the future. And it's that when we have a group of plaintiffs, we're thinking that each group will probably be between 10 and 20. We're just going to file. So
Right.
we're not getting, we're not going to wait until we have many, many more plaintiffs. We're just going to file it then. And then there will be a next batch where we'll file the next batch. And so we're just going to keep doing this because it seems to be the only way to get the agency's attention. And we feel strongly that we have great arguments on the law. It's just not a reasonable amount of time that they're taking to adjudicate these, and that's what they're required to do. They're required to do it in a reasonable time. So I feel very good about these cases, about the strategy, and we're looking forward to getting moving on these.
Okay. All right. And I'm trying to think so I know we get the questions regularly about what's happening on Go and DV. We don't have an answer. We do now think that this case, I mean, we've been telling people for a long time that we were expecting it to probably take about 6 months. We're about at 6 months. So now we're kind of like also getting antsy like the rest of you on there, but we still, they can take as long as they want. There is no time limit for the Court of Appeals to issue a decision here. So, but we think something's probably coming soon on that. So just stay tuned. Anything more than that? I think that's all we can say.
No, we want that decision. We know everybody's really anxious for it, and it's taking longer than people wanted, but that's the way of it. There's nothing we can do. So hopefully soon.
Okay. All right. So we have some questions. And I don't know if either one of us have the ability to actually put them on the screen, but we can certainly read them.
We might just have to read them out loud.
All right. So the first question of substance, I think, is from Jose Bravo. And
that up on the screen. Yeah.
Oh, there we go. All right. So his case has been transferred twice, once in February. And we don't know, it is correct. We had a bunch after the first filing of transfers. Government didn't tell us why. We thought that was probably good news on there, but it was just speculation on our part on what these transfers actually mean. So and we know in the Madhavan case, which was a mandamus case on employment-based adjustment applications, we saw a very sizable portion of our plaintiffs' cases transferred right before adjudication, and that was good on there. When the case got transferred, that meant that it was being transferred because it was a work. It was based on the fact that they were sending it to offices that had the capacity to work on it. But we don't know on there. These cases transferred a couple weeks ago. Most of them, none of the ones after the amendment was filed have been transferred yet. And we did have one adjudication so far, but it seems like there's a stall that's happened. I'm not sure if that's deliberate or not. All we can do is speculate at this point. I don't think that that's that productive. So I don't think, Jose, I would read that much into it, positive or negative. The fact that your case has been transferred a second time on there, we hopefully that's good, but we just don't know. Aaron, I don't know if you have any opinion on that beyond what.
No.
I think you're going to be frustrated on some of our answers on the 601As that we don't have that many answers. But all right, if we have an update on the H-1B FOIA, was this one this is Chuck's FOIA, I think?
Yeah, this is something that Chuck did, and I am very interested to know the results, but I haven't been involved in it, and I don't know, Greg, if you have, so I don't.
I'm pretty sure Chuck would have told us if he had a response at this point, and he hasn't. So I guess it's still pending, but we should hear soon. See Trey Yates. Hey, Trey.
Oh, Yeah, I can give an update on this. So there was a decision from the Supreme Court, which was actually about equitable tolling, which is not what the issue was in Go or the related DV cases. And so the government submitted it to the DC Court of Appeals, basically saying, "Listen, this case favors our position." And counsel for Gomez, on behalf of all the DV applicants, submitted a great response, which basically just said, no, it's something totally different. Equitable tolling is for when a deadline is missed by an applicant for something, right? And there's some kind of reason to excuse the deadline. That's not the case here. Our applicants didn't miss any deadline. They submitted everything on time. They brought the legal action before the close of the fiscal year. They got an order from the district court before the close of the fiscal year. So it's just not applicable. And we explained that to the court, and I'm confident that they'll see that.
What's our next question? Will we see approvals this week?
I'm guessing that's for 601As. I hope so. But I don't know.
Yeah, I mean, we haven't seen anything on the. So basically, just to let people know kind of how it works for us, is we have a data scraping tool where we see all 300 plaintiffs in a sort of in a table format and can see what's happening. I think we get updates about 4 times a day on that, so it's a pretty good tool for us to be able to see in real time what's happening on cases. We haven't seen anything since March 1st, and that was there is an update. It's interesting because you learn sort of like a lot about from this data scraping tool about how USCIS kind of classifies each step in their activities. So that person was one of our transfers from the first batch, where it says case was transferred, a new office has jurisdiction. That was on February 10th, and then on March 1st, correspondence was received and USCIS is reviewing it, which is obviously good. If that means an officer updated their system to say they were working on that application. So that's probably a good sign for that particular person, because I don't think the officer would have updated that if it was just sitting basically in the mailroom or sitting someplace in a cabinet and wasn't actually being worked. So for that, at least that one person, that means that case is moving. So hopefully we'll start to see more of that. But that was also a week ago, and that's the last update we've had. So and it may actually be probably as deadlines are getting closer for the government, that we start to see things moving a little bit more quickly too. All right, Aaron, what's next?
We see, let's see. Erica Romo says she got an appointment overseas, but I'm going to have to cancel. Potomac, 36 months and waiting. Yeah. I'm guessing that's a 601 case. If she already got an appointment overseas, although I don't know.
Yeah, Erica, if you want to give us more details, you can. Mm-hmm. All right, Leonel, why only one case was adjudicated? The plaintiff, that is not clear yet. The government, unfortunately, it's not like they're going to tell us basically what their plan is. Sometimes what ends up happening is that once the judge, once we're in front of a judge once and the judge makes it clear that that the judge would like to get these cases cleared out, a lot of them will move more quickly. But it's not apparent yet if there was a change in strategy, and that's why none of the new people have had their cases transferred, only the older people have, or what. But we just don't have that information yet, so I don't think we can speculate. Usually, at least the 150 or so that were transferred, not everybody in the first batch was transferred on there. That's usually good though, but we'll have to wait and see. All right, what's next? Kiara Elliott. It's just normal compared to previous lawsuits. Yeah, I mean, I think what we've seen in other suits is that there are quiet periods, and then sometimes we'll see a lot of activity in a short period of time, and then quiet again. I mean, it's hard to say, what we're seeing here. I think that we'll monitor obviously in the next couple of weeks, but Aaron, we have this hearing that's coming up. And maybe that the government's kind of waiting to see what happens, if it sort of like seems like it goes well for them, or the judge seems like she's angry. That's going to probably have some bearing on what we see happening on these cases, my guess.
Yeah, I think that's fair to say. I think the more onerous that it's going to be on the government, including the lawyers, the agency officials themselves, the more likely they might be to try to be amenable to getting applications adjudicated. And something that is quite onerous is discovery, and that's what we're pushing for. So
yeah, I mean, I don't know if because I've missed a couple of these for travel for the last couple of weeks. I don't know if Chuck's talked about this particular judge in Seattle, but she's a good one as far as her having ruled on a very similar case that made national news. I guess it was 2 years ago or a year and a half ago, and it was Jesse's case, and that that presumably, even though the government may be kind of posturing at this point and with some bravado, they have to know that this judge is not the best draw that they could have gotten on there. So, my guess is that they're going to see how things go after the first hearing, and and then we'll probably start hopefully seeing some activity. All right. So that, I think Brittany's case has already been answered. A question has been answered about transfers. Loose about the 60-day and the deadline. So, Aaron, why don't you talk a little bit about what our deadlines are in this case for the government?
Yeah, well, it's all kind of effectively their reply is going to be a motion to dismiss. And because they have an interest in trying to get that filed to try to delay discovery, because that's the basis of their request for a delay of discovery, my expectation is that they're going to file the motion to dismiss as soon as they can have it prepared. When that's going to be, I don't know. The complaint was filed on the 23rd, if I'm not mistaken, or served on the 23rd of January, which would give 60 days from then. So it's going to be before then, but my expectation is it's probably going to be next week, if not late this week, that we get their response in the form of the motion to dismiss. To the second part of the question, there are a lot of similar ones in the chat that I can see. Are we going to see any approvals soon? We hope so. We don't know that. They don't tell us, hey, we're going to start trying to approve cases soon. I would say that to look better for the court, obviously they will try to make it look like they're moving on cases, and so that often happens in our experiences, that we see movement as deadlines go. And I think Greg's point is right, that if there's a hearing in front of the judge and she does not seem amenable to delaying discovery or to dismissing the case, I think that'll be further motivation for them to get moving on cases. But will we see them soon? Are we going to see them this week, next week? That we don't know.
Yeah. Guadalupe is asking about, so we were actually just asking about this ourselves. We cannot see in our scraping tool where the cases are being transferred to, and whether they, so I guess the plaintiffs are when they get. I mean, I don't actually. I'm not sure that they plaintiffs necessarily know where their cases have been transferred to if they're seeing the same thing online. Do they, Aaron? Do they send them a separate notice? Do you know when that happens, as far as like letting them know exactly where their case is?
It'll show up on their. Well, I think it's kind of unreliable, the USCIS online status. It'll show up there, but then also likely if they log into their USCIS account, that's where they'll see it, and they may get an email notification when that happens. But to the question of Guadalupe is would it be possible that they are transferring cases to field offices? I've never seen it before for a 601A that they transfer to field offices. They've always kept it centralized. Is it possible that in response to this action that they're trying to dedicate more resources, including field office resources? I suppose, but I'll kind of believe that when I see it. So for now,
yeah, I mean, we know in this Manavan case they transferred to local offices, but they had already been adjudicating. Yeah, I mean, I'm going to say the local offices had already been adjudicating at least some I-45s and employment-based cases already for a couple of years before that was happening, and they had officers that were actually trained in that. Aaron, I mean, if they sent these to local offices, then presumably they're going to have to do some like training for these people. It's not like they can just send them to random USCIS officers and expect them to work on applications where they haven't actually gotten training.
Right.
So it seems if they were doing that I'm not sure that would be a good sign. But I mean, I think transferring to other service centers where they maybe have more capacity, maybe, but it's that would certainly, I think, would be one of the issues with doing local, in addition to the fact that they have never done that. All right. What did USCIS counsel say their plan was for the 601A cases? Well, you got to remember kind of like what's happening in these hearings is that we have the Department of Justice lawyer, and usually they are just taking information. They say they're just taking information back to their client, which is the USCIS. So they're not going to reveal very much about like what they're going to be doing on the cases themselves. And I don't think they said anything particular about that today. They were basically interested in like what our positions were regarding settlement. And as Aaron said, we're not going to get into the specifics of that today. Talked about scheduling things, gave a little hint about some of their strategies that they're likely to be looking at. And that is really the extent of it at this point, I would say, Aaron.
Yeah, I mean, they gave us their plan for litigation, which is filing a motion to dismiss, like I said. Right. But as far as a plan for the actual adjudication of the applications, what we really care about, no, they haven't given us any information on that.
No, and that might, once if they actually are, if they're legitimately engaged in settlement discussions, which, sort of we know from Shumalina case that they may say that they're doing that, and that's a different story than what the reality is. But we, maybe once that happens, when we're having that conversation, we'll have a better idea of sort of like what their specific plans are. But we, at this point, don't have any information to pass on to you.
I see a question from, I think it's Ivo or Evo Andanov. And is it possible that the answer that they receive is a request for evidence and not a final adjudication? Yeah, absolutely possible. That instead of getting an approval, that you get a request for evidence that you and your attorney, if you have one on the agency side, need to respond to as soon as you can.
Yeah, and I will say, sort of in kind of like the mandamus playbook for the government. Sometimes they, they'll be ordered to to move a case, and they'll just basically ask for more evidence and kind of delay things even more. But so I think that's right.
The next one is Claudia Gehrman. Are we going to see, for people who joined in the amended complaint, any movement?
Hopefully.
Sorry, just don't know when or how that'll happen, and a guess is not going to be worth anything. So Hopefully we see movement for all of the people who have joined, including the second batch soon, but I don't want to hazard a guess. The next one is Joe P. He says that since Charles isn't here, that me and Greg need to be brave and just make a prediction on when the decision is coming out on the DVE case. Sure, I'll hazard a guess, and it's worth nothing.
Don't go to Las Vegas with this.
I think we'll get it this month. And when I'm wrong and it's not here, then you can hold it over me and say that I don't know what I'm talking about. So
I agree with Aaron. I think that I was expecting it last month, actually. We lost Aaron. Hopefully he's coming back in a second. He must have just got an internet break. All right, I'll keep going until Aaron comes on. So Lionel asks about the fee increase rule. So a couple things to note about that. One is they are only looking at comments at this point on fee increases. And beyond that, a lot of the expectations are that if they, whatever comments they get back, they're probably not going to be doing actual fee increases until later in the year. So I don't think that's going to have much of an impact this year on the I-601A cases. I think probably the only thing that's going to, help is at this point in improving things is this litigation is in all likelihood, or somebody in the administration in the White House decides that this is a priority. Sometimes that happens without litigation, but if somebody in authority decides that they are going to prioritize, then you may see things moving. But the filing of the litigation itself has gotten obviously their attention. So even if judge, even if it's a while before a judge makes a decision on this, it's had some, it's had some effect as far as at least raising the profile of this issue with the administration. All right, looking for more questions here. Kevin is seeing that could USCIS fudge processing times by approving with less time? I'm seeing on Reddit people are being approved with as little as 20 months. So that is the that's one of the reasons why that I hate the published processing times, because it does seem like in some cases we're not getting the reality. But remember, on those times, that's average times that these cases are supposed to be taking. There are always people who are outliers and see approvals faster, and then presumably there also are people that are going to be lower, that are taking longer than the 30 some odd months that are on the published processing time. So I wouldn't necessarily read that much into reports when you see people that have, and I think also it says that 80% of the processing time, I think, is for 80%, and the 20% are adjudicated outside of those times. So sometimes people are adjudicated more quickly as well. Aaron, are we back?
Sorry.
I don't know where you
My
went.
camera shut down and I had to figure out.
So Aaron, I was answering this question about processing times and why sometimes we see people with shorter processing times. And I was trying to explain that the published processing times are, I guess, apply to the 80% of the, so presumably 20% of people are falling over and under that number. But that's an average for this. So they take 80%. I don't know. It's kind of a weird way that they do it, but they take 80%, say for this 80%, I guess it's sort of like the 80% in the middle, that this is the average processing time for that block of people. And then, presumably there are, of the remaining 20%, some of them are over and under.
Yeah, it is. I think that the way they do it is the 80% means you take 100% of cases for whatever the time period they're considering, and then they say 80% of those were adjudicated within whatever it is, 39 months. And the other 20%, that means went over. So if they're, I think, okay. Yeah.
So the 80% could be to conclude the 20-month people.
Yeah, exactly. They would be included.
All right. So I was describing that wrong. So just erase what I just said for the last minute. Okay. What do we want next? somebody will go through a manual. Will it be possible for him to do adjustment from his so that I don't know if we want to answer.
Joe P. Sure.
Yeah.
If somebody went through from Mexico to the U.S., would it be possible, and how complicated for them to adjust from asylum seeker to green card holder? Way too many unknowns to say that. Adjustment of status, I can tell you, generally, with exceptions, requires somebody to have been inspected and admitted or paroled into the United States, and then have a petition for them. But we're not going to be able to get into whether that would be possible for any particular individual.
Nope likes my beard.
Yeah, and good on the beard.
Yeah.
All right. I think that Cordero, I think is the last one. And the question is it possible that they're doing stall tactics because they don't have enough adjudicators? Yeah, so like just transferring cases everywhere to make it look like they're doing something. I don't know.
Well, so they haven't discussed. We haven't seen any public comments from them lately. I think it's really been since last June that we've seen sort of a big comment about hiring at the agency. But what we did hear last summer from Urjadu, the director of USCIS, was that they were planning by the end of the calendar year being at 95% staffing. And they were at about 80% I guess at their low point, they were at about 80%. What we haven't heard is an update on where they are on that. But in theory, they should be pretty close to where they, to pre-COVID, as far as what the numbers were looking like. And of course, they have people to train and that, but they also, there have been some positive signs in the last couple of weeks out of USCIS that things might be improving at the macro level. One is that they announced new premium processing categories this week for I-765 employment authorization document applications for students. That's a fairly large population that are now, and they said that they were not going to be moving people into premium processing until they felt like that, at least in that particular category, that they were in a position to be able to adjudicate those cases. Now, premium processing for I-765s, Aaron, I believe is 30 days, not 15 days. But nevertheless, so they have a little bit more time. But I saw that as a good sign that they feel like they have that. And they also are moving more and more cases into e-filing, which is a big labor saver for USCIS because it's you guys that are entering the information directly into the system and not USCIS contractors. That basically the way it works with paper applications is they get the application and then somebody is manually retyping that information into the USCIS system. So that delays things in the mailroom. Then it delays things as far as that, that process goes. So the e-file cases tend to be going faster. But anyway, I'm only mentioning all that because as more and more of these things, those are sort of signs that things are getting a little bit better at the agency as far as its ability to be able to move cases more quickly. We know that the e-filed cases are being adjudicated more quickly. We haven't seen the sort of the statistics published by the agency, but we know this from the anecdotal evidence we're hearing from our association, our bar association. So all that being said, I think that they just naturally should be able to improve. Now, the one thing that makes me, and that's the optimistic side of the story. The pessimistic side of the story is what we saw in the fee rule. So USCIS has proposed a fairly substantial fees across the board. That would be fine if that actually meant that you're getting faster processing. But one of the things that was hidden in the report that David Beer at Cato did a nice job of reporting on is they publish for each type of case that they're asking for a fee increase, they have to explain how much time it takes on average to work that particular kind of case. And David had done a comparison to the 2019 fee increase rule or proposed rule that actually never went into effect, but they published the same data And he was showing that there was something on an average of like a 40% increase on each type of case in the average amount of time that USCIS was reporting that they were taking. So that's a very bad sign. It just means that if you're just throwing more money at a problem that's getting worse of their own accord, and why are they taking so much longer for each kind of case? Is it they have lesser trained people? Is it that some of the forms have grown to be much larger forms over the last couple of years where they're adding a lot of questions? There's could be a lot of reasons for that, but that is not a good sign. So I don't know if you sort of have any comments regarding, sort of like forecasting where you think USCIS is going to be in the next 12 months as an agency and its ability to finally get their backlogs under control.
I submitted a comment to the proposed fee increase, and my point was that no money, whether it's from Congress or from applicants paying increased fees, is going to fix the problem at USCIS. It's a cultural problem.
Mm-hmm.
It's a problem of adjudicators not applying the legal standard that's required by law, which is the preponderance of the evidence standard, and instead they tend to issue RFEs and do site visits and just use incredible amounts of resources for oftentimes where it makes no sense to do that. If you just use the right standard, the case would be adjudicated. And obviously there are times when they need to issue an RFE. There are times when they need to figure out if somebody qualifies. But, doing this every day, like Greg and I do, the things that we see are just incredible as far as the wastefulness of adjudicators' time. And so my point is that they need to fix a lot of things in-house to make it to bring these processing times down. And I'm okay with fee increases from time to time. It may be necessary, but without the corresponding cultural change and training changes, it's not going to solve the problem.
All right,
sorry, that's pessimistic.
That's probably a good place to leave things for today. And Johan, thanks for the nice comment at the end. And we will. So this is recorded, obviously. So go to our YouTube, or it's actually probably on my Twitter, and you can watch the recording. I know Sarah was asking questions about whether we discussed. So we talked at length in this call about 601As, and you can just go back and watch the recording, and you can find that. And we will see you next week. Hopefully, we'll have a full crew.
Yeah, and I'll just make one more comment before we go. For those who are kind of new to these because they came in with the 601A case, and the people who did the diversity visa, they've been with us for a long time, so they kind of know how it goes. But for those who are newer, just so you know, sometimes there will be big, important news about the cases, and a lot of times there won't. So we'll give you the information that we have. I do expect actually some news in the 601A cases in the coming weeks. Maybe, I don't know if it'll be next week or the week after, but there's a lot going on in that case. And so stay tuned there. But there may be periods of time where we have these weekly calls and there isn't any big substantive news, and that's just how it goes. So we'll give you the news when we have it, but sometimes we won't. But thanks for joining us today.
All right. Thank you, everybody.
Thanks.